Hello and welcome to MoLawNow. My name is Cindy Lash and I'm the editor of Missouri Lawyers Media. Today we're welcoming attorneys Charles Weiss, a partner with Bryan Cave Leighton Paisner in St. Louis, and Jonathan Potts, an associate with Bryan Cave. While their practices primarily deal with business and complex litigation, they're joining us today to talk about their involvement in a very different case that began 38 years ago. Curley, Jonathan, and their colleague Stephen Snodgrass have worked for years to clear a Missouri man, Donald Doc Nash, following Mr. Nash's conviction for murdering his girlfriend, Judy Spencer, near Salem in 1982. Although Mr. Nash has consistently denied his involvement in Ms. Spencer's death, a jury found him guilty in 2009, and he spent 11 years in prison before the Missouri Supreme Court threw out his conviction earlier this year. But he remained at risk for another trial until October 9th, when Dent County prosecuting attorney Andrew Curley announced that he'd dismissed the murder charge and would not seek a new trial. Had Mr. Curley opted to move forward, the trial had been scheduled to start this week. So, gentlemen, welcome and thank you for joining us today. Good morning.
Thank you, Cindy. Good morning.
Thank you. Good morning.
So first of all, how is Mr. Nash now that he's finally reached the end of the road with this case?
Mr. Nash is enjoying his freedom. And when we talk to him, he says, "You know what I'm doing now?" And then he answers his own question. He said, "I'm sitting on my front porch in my rocking chair, just enjoying the day."
How long have you been involved with this case?
We got involved in the case in 2012 when two deputy sheriffs who were very deeply involved in the initial investigation of the crime came up to visit us to ask us to take on the case because they believed he was innocent.
Charlie, we talked with you before some months ago after Mr. Nash's conviction was overturned. Can you update us on the new DNA evidence that convinced the prosecutor to no longer pursue a new trial?
We received a call probably about 2-3 weeks ago now from the Attorney General's office in Jefferson City, who advised us that they had done some new testing in preparation of the trial that was going to begin this week. They told us that they had tested, among other things, the shoestring that was used to strangle the victim. In 2008, that shoestring was tested, and the only DNA they found on it was the victim's. There's so much of the victims that overwhelm everything else, and they couldn't get anything else other than the victim's DNA off of it. We then had it retested in 2015, same results. The only DNA they found was the victim's. The Attorney General's office then had it retested more recently this summer, I think this fall, and they found the DNA of two unidentified males on the shoestring, and it was not Donald Nash's DNA. They also told us that under the new protocols for testing DNA and identifying the DNA to a particular person, the protocols had changed, and they could no longer even testify that the DNA that was found under her fingernails initially that they identified as Mr. Nash's, they could no longer say that was Mr. Nash's DNA. And so I think they believe that, and they had no other evidence to convict Mr. Nash of the murder, and they told us they were going to go ahead and dismiss the charges. They said they could not ethically proceed to continue the prosecution because of the lack of evidence.
For either of you gentlemen, for folks that maybe haven't followed all of the ins and outs of this case, and there have been many, can you talk about the fingernail clippings that you just mentioned and why there were issues with that DNA evidence and why that had been so critical to the case?
Jonathan, you?
Yeah, absolutely. So for 26 years, Nash was not arrested for the crime. It happened in 1982, and for 26 years, they investigated various suspects. He was obviously investigated initially because he was the boyfriend. He's the most obvious person that anyone's going to try to check on for any crime, regardless of whether he's a legitimate suspect or not. But really quickly, they figured out he didn't even own a shotgun. They also tested his hands for gunshot residue. Within hours of the murder, the gunshot residue test was negative. And so it's pretty easy to see why the case against him dissolved. Then 26 years later, at the urging of the victim's family, the Missouri Highway Patrol tested the victim's fingernail clippings. And when they did that, they found this minuscule amount of DNA. It was a mixture of the victim's DNA and what they said at the time was Mr. Nash's DNA that amounted to 5 billionths of a gram. Now, even though they found that, even the investigators knew that it wouldn't even mean anything if it were Mr. Nash's DNA, because it's a well-known phenomenon that romantic couples and people who live together are going to share these trace amounts of DNA underneath their fingernails. You can imagine it not only with intimate contact, but just being around each other, touching each other in the kitchen, eating meals together, grazing each other's arms, faces. You're going to have this tiny, tiny amount of DNA that gets transferred. So what they did is they invented this theory that's unknown to science, that because Miss Spencer had washed her hair the night before she was murdered, it would have eliminated Mr. Nash's DNA from underneath her fingernails. And when I say that that was invented, there is no study in the history of the world, no criminal prosecution in the history of the United States that has ever relied on that theory. And that was the linchpin and the only reason that Mr. Nash was convicted of the murder.
So then we get to this point when we're looking at the evidence again, and the fingernail evidence is degraded to a point that there's no more value or no more additional analysis that can be performed.
That's correct. Not only that, is that, as I said, the standards had changed. And my understanding is that under the standards that they used in Mr. Nash's case in 2008 and 9, was that if all you needed was 5 loci, and today now you need at least 9 loci, and don't ask me to explain too much more than that, to identify someone. And so because the standards now are more sophisticated, they could no longer put an expert on the stand and say that the DNA that was under her fingernails that they, in 2009, that they discovered, they can no longer say that was Mr. Nash's DNA.
And even so, from the beginning, we've always said it's meaningless, even if it were Mr. Nash's DNA, because of that phenomenon we discussed. And also the fact that this hair washing theory just really has no teeth to it whatsoever. It doesn't take a lot of common sense for it to fall apart. The example we always give is, imagine you go out and work in the garden and you get some dirt underneath your nails. It doesn't matter how hard you scrub. You can sit there in front of a sink, you can take a shower, you can scrub, and then sure enough, you're gonna get out and you're still gonna see it underneath your fingernails. So to say that it was going to eliminate all the DNA so that a mixture of 5 billionths of a gram wasn't going to be left, there was no basis for it whatsoever.
I think in addition to that, the so-called expert that testified at trial has said, in her opinion, the hair washing would have had a great effect to wash it all away. In 2017, when we took her deposition in preparation for the retrial or the habeas corpus, she now testified that she could no longer say that it would have had a great effect. And so she changed her testimony, and I think that was a key fact for the court to reverse the conviction of Mr. Nash. And the other thing that, as we proceeded with this habeas corpus, we also had the shoe from which the shoestring was taken to strangle her, tested for DNA, and we discovered a male's DNA on that shoe. Again, it excluded Mr. Nash, and it also excluded the policeman or the patrolman who had picked up the shoe to bag it for evidence. So that also was a key fact. That was new evidence that we had discovered along the way.
How significant and how unusual is it that the Missouri Supreme Court was willing to take another look at this case after so long?
It doesn't happen very often, put it this way. Jonathan has some statistics, I think, on that. But.
Yeah, I think that we've looked at it, and I don't know the statistics off the top of my head, but it's something like when the issue is innocence, I think it's the court's only granted maybe 3 or 4 preliminary writs of habeas corpus over the past 5 years out of hundreds and hundreds of petitions. And you can imagine a lot of them probably have no merit on their face. but it's really, really difficult to separate the wheat from the chaff and to realize, which ones have merit. And so we definitely feel fortunate that in this case and in another case that the Missouri Supreme Court was able to look beyond the pleadings and realize that there was something going on here.
This was our fourth case since 2011 where a court has vacated the conviction of a person who has been sentenced to life in prison for murder. So it takes a lot of work. This case, as I said, we started in 2012.
Quite a track record. Now, you've also filed a memorandum taking a position that double jeopardy has attached so that Mr. Nash cannot be recharged. Where does that stand?
Go ahead, John.
Yeah, so the memorandum isn't something where we're expecting any sort of ruling from the court. Basically, it's just clarifying the difference between double jeopardy under the Eighth Amendment to the U.S. Constitution and double jeopardy under Missouri statute regarding retrials. And basically, all that we are trying to make clear is that because the prosecution's nolli prosequi didn't actually state that the dismissal was with prejudice, we wanted to set the record straight that Mr. Nash did not consent to any dismissal without prejudice, and that we consider the case to be over. This isn't something where we struck a deal with the prosecution and they said, all right, we'll drop it for now if you agree that we can do it without prejudice. That's not what happened. We were going to go to trial this week. We were ready for it, and it was going to happen. What happened for the state, though, was that it reached the point where they admitted that they couldn't ethically continue the prosecution, which, is a pretty momentous thing to occur.
Mr. Nash has spent half of his life dealing with this case, not to mention spending 11 years in jail under what was, in essence, a life sentence. Is he angry? Is he bitter? Is he looking ahead, making plans? You mentioned him sitting in his rocking chair.
Well, I think Mr. Nash is elated to be out of jail. He is back with his wife, who stayed with him during the whole time of his imprisonment. They like to do some traveling. He is not angry. He hopes that they find the person that actually killed his girlfriend. So that case is now unsolved, and there needs to be some more work done to solve it if possible. He would like to have that happen. He's not angry at all. He's not angry at her family who pressed the prosecution to charge him. He has sympathy for their family, and he is just elated to be out. So he's one of those persons who never was in trouble before. Worked all of his life in the mine down there at the Amax mine before he was arrested. Grew up in the Salem area. A lot of relatives still live there. So he is happy to be out. He, again, as I said when we last talked with him, he just hopes that they find the person who really did this. It is unusual that there's just no one has come forward with any evidence as to what happened to this poor victim.
It's a long time.
It's an unusual case. One of the more unusual cases that we've ever involved in.
When you spoke with my colleagues about the case last week for our print and online story, you alluded to many mistakes being made during this case. How does that affect your perception of the justice system and the flaws that sometimes enter into these cases that affect the outcome so drastically?
Well, as we said many times over, our criminal justice system is administered by human beings. All of us are flawed, we're not perfect, and we make mistakes. And the justice system makes mistakes. In this case, I think there were a lot of evidence gathering that didn't really happen. There were beer bottles and beer cans found in her car. No fingerprints were taken of those. They were discarded. The fingerprints of two suspects were found on the window of the car. It was 10 years before they finally identified those fingerprints. Mr. Nash had never been charged in the first place. The exculpatory evidence basically established that he was innocent. As Jonathan said, she was killed with a shot. After she was strangled with a shoestring, someone shot her through the shoestring in the neck after she was dead with a shotgun. Doc Nash never had a shotgun, never owned a shotgun, and that was pretty much proven. They tested tested him for gunshot residue within hours after the murder, and that was negative. There were tire tracks of a vehicle found at the scene where her body was found, fresh tire tracks, and those tire tracks neither matched Doc Nash's or Donald Nash's truck or Judy Spencer's car. So neither of those vehicles were at the scene. So somebody else was there. They didn't do much to identify who it might have been or to try to find out what kind of car or truck it might have been. So there were things that were done. There was exculpatory evidence that should have indicated that he was innocent. He should have never been charged. That was the major mistake. And the major mistake was allowing this lab technician from Jefferson City Highway Patrol to testify about the effect of hair washing. Jonathan said that was the key testimony and fact that led to his conviction. That was a mistake.
Even in cases that don't have constitutional problems, like false testimony, excluding evidence, ineffective assistance of counsel, even in those cases, proof beyond a reasonable doubt isn't proof to a mathematical certainty. So you're always going to have this gap that's left there where you're going to have innocent people who are going to slip through. And it's important that our justice system has, frankly, the humility to admit its mistakes and to correct them, because the search for truth is really what's paramount here. And that's what happened for Mr. Nash.
What has this case meant for the both of you? You've been involved in it for a long time.
Well, we do it because I can't imagine anything worse than an innocent person being in jail. I wouldn't want to be in jail for a week. And so we were convinced that Mr. Nash was innocent from the time we first got involved in this case, continue to be convinced, and certainly are convinced today. And so it's a lot of satisfaction for us, I think, to be able to save a person's life and do what we can as lawyers to make sure he or she enjoys freedom again.
And for me, I started this case when I was still a first-year associate, so it's definitely had an impact on the trajectory of my career. In law school, I didn't show any interest whatsoever in criminal law, and frankly, I got asked on this case. Charlie didn't even know who I was. So another associate who was leaving the firm asked me to step in, and it's become something. It's very important to me professionally. I think it's our civic duty, especially when we're fortunate to be in a firm like this that has the resources. We need to be stewards of our community, and we need to go out there and correct wrongs when we see them. We take these cases only if we think that the person is innocent. There are plenty of cases out there where we could try to create some new constitutional law on interesting issues that maybe impact some guilty people as well as the rest. And those are important things. But with these cases, we know that they're going to take years. We worked this case for, almost 9 full years at this point. So if we're going to invest, our personal time, blood, sweat, and tears, the most important thing is that we're correcting this wrong.
This isn't your first foray into wrongful conviction work. You mentioned that before, that this is the 4th time that you've helped someone to be freed. What's next for you in this area?
Well, we'll continue to work on any innocent case that comes our way. We have a lot of applications from prisoners and other people, but right now we do not have one that we've identified to take on for somebody who we believe is innocent. But there will be others that come along.
Once again, our guests today have been Charles Weiss and Jonathan Potts of Bryan Cave Leighton Paisner, both of whom are notable advocates for the wrongfully convicted. Thank you both for sharing your perspective with us today.
Thank you, Cindy.
Thank you, Cindy.
And I'm Cindy Lash from MoLawNow and Missouri Lawyers Media. Thank you.